Welcome, everyone. I'm Scott Kafker. This is an Appellate Bench Bar Conference, which is a joint effort of the Supreme Judicial Court, the Appeals Court, and the Flashner Judicial Institute. As Socrates famously said at his own trial, the unexamined life is not worth living. Without examination, we don't learn from our mistakes. We tend to exaggerate our virtues, and we tend not to learn how to live a better life. The same can be said, of course, for courts and the administration of justice. Today, with all of your assistance, we will examine the inner workings of the Commonwealth's appellate courts. Following up on an extensive survey done by the Flashner Judicial Institute that was sent to 4,500 appellate lawyers and responded to by 700, which is a pretty good track record in these days. And we hope to engage, and I think there are going to be 265 of us here today in a dialogue about that survey and what we've learned, and hopefully get a better understanding of what the appellate courts are doing right and also what we need to do better. We strongly, and I mean this, emphasize to each of you, please participate. No potted plants today, no shrinking violets, because there's no penalty. Unlike Socrates, there will be no hemlock for what you do. For those of you who help examine the courts, just wine and cheese at the end of the day. Before giving you an overview of how this afternoon will proceed, I want to thank a number of people who have made this happen. In your handout, I believe, is a long list, and every one of those people deserve a round of applause. They really have just done phenomenal work. As president of the Flashner Judicial Institute, I'm particularly proud of what our CEO, Peter Agnes, who originated this idea, our executive director, Melissa Nalraki, and our super staffer, Kimberly Gollop, who made that survey happen and helped make today happen. But there's one judge in particular who I want to single out. As many of you know, internally in the court, you're known by your abbreviation, your last name. They take your initials, and every communication is done inside the court through your initials. So Justice Catherine Hand Rotalakis, I assume, is HR. Given what she's done for the past couple of months, solving every conceivable problem and removing every imaginable obstacle, and believe me, you have no idea how many there were, I conclude that HR stands for Judge Hercules. And that's how I'm going to refer to her. Where is Judge Hand? She's somewhere hiding. She should have been giving this speech herself. Where is she? Okay, she's not even in the main room. That's typical of Judge Hand. She's hiding. So today's agenda will begin with remarks by Chief Justice Budd and Chief Justice Green. We will then hear from Rebecca Kiley, who has served with distinction as the Public Defender Division's Chief Appellate Attorney since February 2018, and Mark Fleming, who is the co-chair of WilmerHale's Appellate and Supreme Court practice, who has appeared in 275 appellate cases and made 8 oral arguments to the U.S. Supreme Court. We're going to run the first session, this one here, like an Olympic relay race, with each speaker just passing the baton on to the next one without any further introductions. Then we're going to proceed to breakout sessions, and we have a lot of ground to cover in those breakout sessions, and there are a few ground rules as well. The first is try to follow your facilitators. They've done an enormous amount of work going through the surveys and helping to channel in a more structured way the discussion today. The second ground rule, which is, I think, the most important, is this is not a forum for personal complaints about a particular judge or clerk. If you're going to name a particular judge or clerk, this is not the time. You will have opportunities to do that elsewhere, but that's not today's event. So nothing directed at an individual judge. The report, I might add, that's going to be done for this will also not contain any of your individual names as well. They'll summarize what you say, but you will not be identified by name. That report is going to be prepared by Justice Mary Sullivan, retired Appeals Court Justice Mary Sullivan, who's gratefully and gracefully agreed to devote the first year of retirement to this project. So we're incredibly grateful for that. And the work she's about to do is going to be based on the work of the note takers, who are mostly the appeals court law clerks, and I want to thank them too. I also want to remind them that the reason we know what Socrates said 2,422 years ago was there was a note taker in the room, which was Plato. So I want each one of those note takers to think of themselves as Platonic guardians of the truth, not note takers for our session today. Last but not least, I want to thank all of the lawyers who have come today. We know you have many commitments and could be doing the work that you get paid for, writing briefs, managing your practices, and assisting clients. We really appreciate your willingness to help us make the courts better for both you and us, and I think this is going to be time very well spent. With that, I pass the baton on to Chief Justice Budd.
Thank you, Justice Kafker. Good afternoon, everyone. I want to thank Justice Kafker and Justice Hand, the Planning and Steering Committees, and the Flashner Judicial Institute for all that they've done to organize this event. We're so pleased to welcome you all who've generously taken your time to join us this afternoon. As you know, when we hosted this event 5 years ago in 2018, it was a different SJC Chief Justice who delivered welcoming remarks. I was still a relatively new justice. The world has changed dramatically in those 5 years, and in so many ways, including how he embraced learning from this session, I still sorely miss Chief Justice Gantz. He and all of the justices recognize that you, the members of the appellate bar, truly are our partners in justice. Through your briefing and arguments in individual cases, you help to inform the opinions that we issue. But equally important, through your comments and forums like these, you help to shape how we structure the appellate process. We truly appreciate your input. You are the mirror that helps us see ourselves more clearly and recognize where we need to improve. At our last appellate bench bar conference, you told us that you wanted more clarity and transparency in our procedures and operations, and we've sought to provide that. We've reorganized our web pages to make it easier to locate essential information. The SJC's Clerk's Office for the Commonwealth provides online guides that describe the process for bringing appeals before the full court and for preparing for oral argument. That office has also established a listserv that provides regular email updates about recently entered cases, notices of invitations for amicus briefs, and notices of new rule changes and invitations to comment on proposed new rules. The listserv currently has over 800 members. If you'd like to learn more about it and how to sign up, all you have to do is search online for Supreme Judicial Court listserv. With regard to appeals and first-degree murders, Chief Justice Gantz and Justice Gaziano, retired Justice Botsford, who's the special master who's overseeing that docket, and Clerk Fran Keneally met with assistant district attorneys and defense counsel to discuss their concerns about the docket and to develop a process for handling those appeals more promptly and efficiently. With input from the bar, the court adopted a standing order that provides for regular status conferences to deal with any complications earlier in the process. As you know, we also have the SJC Clerk's Office for the County of Suffolk. That handles our single justice cases and attorney discipline cases, as well as bar admissions and other attorney services. That office also has posted extensive information online describing its procedures and the services that it offers. In addition, both clerk's offices now accept e-filing, and both provide online instructions for doing so. And as you likely know, the calendars for the arguments before the full court and the single justice are available online. I want to take this opportunity to thank Fran Keneally, the SJC clerk for the Commonwealth, and Maura Doyle, the SJC clerk for the County of Suffolk, as well as their staffs and our web and IT teams for all that they've done to carry out these improvements. They also deserve our thanks for their extraordinary efforts to keep our court and their offices operating and accessible during the COVID-19 pandemic. Nearly overnight, they had to shift to remote hearings and electronic filings due to restrictions on in-person contacts, and they did it with amazing speed and success. All our staff worked hard to adapt quickly to so many new ways of doing things. But we also recognize that there's always room for improvement in our procedures and operations. You've already given us much food for thought in your detailed responses to the online survey that we circulated. And we look forward to further discussions in the breakout groups this afternoon. Thanks again for being here.
Well, I am very pleased to be back here with all of you 5 years on after the last bench bar that we held. Justice Kafker, in his introductory remarks, invoked the philosopher Socrates. I want to bring up a different philosopher, Jerry Garcia. What a long, strange trip it's been. We thought when we held this event 5 years ago that it would be a good idea to do it every so often. And here we are again, but little did we know back in 2018 what 3 of those 5 years would be like. Obviously, the time that has passed in between has been dominated by the pandemic and what we've learned, what it's challenged us to do. But I also want to note that during that intervening time, the appeals court hosted and celebrated its 50th anniversary of its creation in 1972. That was last year. And 2 years ago, in October of 2021, we hosted the annual conference of the National Association of Chief Justices of Intermediate State Appellate Courts. In those 5 years, more than a third of the justices on the appeals court have newly joined the court. They were not here as justices 5 years ago. That count, by the way, includes our newest justice, Robin Toon, who was confirmed a little over an hour ago in a unanimous vote by the Governor's Council. In the report following the last bench bar conference, we at the appeals court made 3 commitments, and I'm quoting directly from the report, to review and possibly revise our manual of internal operating procedures to permit posting on the appeals court website, to review second panel practice and evaluate en banc or other alternatives used by other intermediate appellate courts, and to work with the bar to reduce briefing delays and identify a realistic and sustainable briefing schedule. We completed the first of those commitments. We made significant progress on the second, though that's ongoing, and the third is in progress. Let me talk about each of those. As to the operating procedures, and by the way, while I'm on the topic of newly appointed justices, if you will recall, the challenge to us to develop and post those internal operating procedures for public viewing was posed to us by none other than Bessie Dewar. That name may ring a bell for some of you. The project to do that was disrupted, like everything else was, by the pandemic, and that disruption was really in 2 respects. The first, of course, was that we faced other urgent priorities. But the second, and as we got into the project, more significant impediment was that we faced, as we undertook the effort, so many changes in our operations that required updating of our own internal procedures that the challenge was not revising them to take out the very little bit that we thought was not appropriate for public revelation, but to realize how much we had changed in just a short period of time. But we've now completed and posted the manual. It's available on our website, and maybe some of you have seen it already. If you go to our home landing page and scroll to the bottom of the page, they're all there, and if you have any trouble sleeping, I commend it to you for your late night reading. I will say that having this date on the calendar was an important impetus to complete that project. Those kinds of projects are notoriously difficult to get across the finish line, but I was not going to stand here before you with that commitment unfulfilled. Second panel in en banc. Shortly after the last conference, we established an internal working group who studied the practices across the country among state and federal intermediate appellate courts. They brought forward an initial proposal that was discussed among the justices, and the justices collectively as a group determined not to proceed with that first proposal because it did not provide a mechanism to ensure that the full court had adopted the reasoning in a decision. Anything that called for participation in en banc rehearing by fewer than all of the justices of the court seemed to us to leave us short of the way we have always viewed ourselves and the way we believe all of you view our decisions. And of course, with 25 justices on the court, there are very few spaces that would accommodate an en banc rehearing before 25 justices. Then came the pandemic and Zoom. And coming out of the pandemic with the experience that we all had, conducting very effective oral arguments by a video conference mechanism, we realized that we could fit everyone on a Zoom screen, maybe on a postage stamp size box, but we could all participate, and we revisited the question. We developed some internal protocols, and we announced a pilot a little over a year ago. So far, we have had one hearing en banc. The hearing went quite well, I think. Those of you who have not seen it can see it on our YouTube channel. The experience that we had through that process validated the belief that many of us held that full participation and deliberation is different in kind from reviewing drafts and commenting on draft decisions. But the process with the 25 of us involved is quite unwieldy and time-consuming. We're currently continuing internally to review and evaluate how it might be made more workable. And that also has us considering the question, if not full en banc, then what other alternatives might be available to achieve the same goal in a way that, that is manageable and sustainable. The second panel process, by the way, remains intact. It is an important and continuing measure of quality control. We all benefit from it, and I think it makes the quality of our final work product better because of the comments and careful review that we receive from our colleagues. Briefing delays. We set up a committee that engaged jointly with representatives from the bar toward looking at what were the causes of some of the briefing delays, what were the possibilities, what can be done to try to come up with a briefing schedule and expectations and deadlines that are realistic and sustainable. I think they're, I don't have the exact figures in front of me, but well north of 80% of the cases that are filed in our court are filed outside of the time set by the rule, which means in turn that our clerk's office processes thousands, literally thousands of motions for enlargement. We have a situation, in other words, where the reality subsumes the rule. The exceptions far outweigh the compliance, and that's no way to run an organization. We've not made a lot of progress before the pandemic in finding what would be a realistic and sustainable set of timelines. Post-pandemic, I'm told that most organizations have much smaller backlogs in briefing because of the reduction in trials during the course of the pandemic, particularly on the criminal side. And I recently asked the two co-chairs of that committee, Justices Blake and Massing, to revive that effort and see whether we could, from a new status quo, make headway on that effort. And hopefully we will see some progress in the coming months coming out of that effort. I want to just offer a couple of brief words on the pandemic generally. And I think some of this may echo some of your experience. Obviously, your operations on the advocacy side are different from ours on the adjudicative side. But from my perspective, though the pandemic caused enormous disruption, I'm proud that we were able to continue our operations largely without skipping a beat, including a full slate of arguments throughout the pandemic, including 16 months when we were fully remote. That was due to fantastic and dedicated hard work by everyone on the appeals court, the staff, the judges. They did things that I don't think even they expected that they could do. We discovered new ways that we could do things, and many of those have survived and come out of the pandemic in some adapted form. That includes the possibility of remote hearings and in exceptional circumstances, and also remote work flexibility for our staff. We've leveraged technology to introduce new access and capabilities, including our YouTube channel. I didn't know it was possible for a court to have a YouTube channel, but now not only were our Zoom arguments available in real time and archived, but now all of our in-court arguments in the John Adams Courthouse are available in real time and archived. And that also includes the opportunity for us to host some of our celebratory events, including the recent portrait hanging for Justice Brown, our 50th anniversary celebration last year. So we have been able to make ourselves more accessible, not simply in our rather dry operating procedures, but in our more vibrant activities in the courtroom and in celebrations. This conference, 5 years on, is a combination of looking back at what we've seen and done since the last conference and looking ahead at what we might be able to do together going forward. I've read a summary of the responses to this, of your responses to the survey that Flashner sent around, and I've certainly seen a number of themes that have emerged from that. We'll be talking more about those in the breakout sessions. I look forward to the conversation, and I also want to echo those who come before me and give thanks to the folks that have put this together, particularly Justice Kafker, the learned Justice Hand. She goes by K-E-H, by the way. She has been tireless in her commitment. She has been patient and very thoughtful and gracious as always in enlisting the support and in making this come about. There are many, many others. They are listed in your program. Thank you all for coming. Thank you for being here. Thank you for helping us put this together, and I look forward to the conversation.
Good afternoon. Thank you to everyone involved in organizing this conference. I was in attendance 5 years ago for what was a big success, and I hope we can achieve the same today. And I also want to thank the 700 plus attorneys who responded to the survey and offered their thoughtful comments. I reviewed all of those comments, and it will surprise none of you that on any given topic, this group of lawyers can express the two extremes of every issue and every nuanced perspective in between. Nonetheless, there are areas of consensus and areas of shared concern, even if differences arise over solutions. Mark Fleming and I hope to highlight some of those areas before we head off into our breakout rooms for further conversation. And I'd like to start by focusing on what can very generally be described as attorney experiences with the people of the appeals court and the SJC. And if there is one area where we were able to achieve near unanimous consensus on the survey, it was in our very high praise for the staff of the SJC and the appeals court. A representative comment described those who worked in the clerk's offices as a credit to public servants everywhere. Other descriptors included extremely responsive, very professional, and fantastic. On behalf of the bar, I'd like to express our gratitude to all of the clerks and court officers. There's also a great deal of respect for the justices of the appeals court and the SJC. And I'll pause here to note that Mark and I were somewhat taken aback to be allotted twice the speaking time of the chief justices. And don't worry, I don't think we're going to take it all. But the reason we were told is that today the court is looking more for input than for output. So keep that in mind in your breakout rooms. This is the rare opportunity for us to offer feedback to our appellate judiciary. But I noticed in reviewing the survey results that the topics that lawyers indicated they were most interested in hearing about were the judge's perspective on what makes for effective oral advocacy and what makes for effective brief writing. So we may be here today primarily to offer our feedback to the judges, but we remain very interested in the judges' feedback on our own work. And there was a great deal of praise for the preparation and thoughtfulness of the judges of both court at oral argument. At least some attorneys find oral arguments to be tough but fair or challenging and fun. One attorney wrote, "I do not always agree with the judges, but they do a very good job." This is not to say that attorneys saw no room for improvement. One noted that while most of the judges treat the litigants with courtesy and respect, even when they disagree with our position, sometimes they do not. It is okay to disagree with the litigants, but it is important to recognize that we are there to advocate for our position. And frustration about not always being given an opportunity to fully answer questions was another recurring theme in the comments. No attorney wants to face a cold bench, but at times, lawyers noted, overlapping questions and interruptions of the litigants or between judges can make it feel impossible to finish a sentence, let alone land a successful point. Similarly, one commenter noted that while the justices are generally very well prepared for oral argument, the occasional poorly articulated or meandering question can take up a lot of valuable argument time as we watch our clocks click downwards. And some attorneys expressed concerns about the composition of the appellate bench, noting, for example, the absence of justices who come from the juvenile court. Many of my fellow criminal defense lawyers noted the imbalance among judges with criminal law backgrounds between former prosecutors and former defense lawyers. Now, obviously, the courts do not control their composition, but lawyers are curious to hear from the judges about how they think their collective background affect the development of the law. I'm going to turn to the topic of attorney experiences with technology at the court, which Chief Justice Green has already talked to us a bit about. And of course, as he noted, the pandemic accelerated the use of technology in our legal system in so many areas. Perhaps the most obvious example of this is video conferencing to enable remote, or now sometimes hybrid, court proceedings, including oral argument. And as both Chief Justices noted, the courts transitioned remarkably quickly in the spring of 2020 to make it possible for oral arguments to continue to happen and to happen safely, which at that time meant remotely. It feels a little quaint now to remember that the clerk's offices had to set up practice sessions to teach attorneys how to use Zoom. But we were really grateful for that back at that time. The extent to which remote arguments should continue to have a place in our system was perhaps the most polarizing topic on the survey, with some respondents asserting that, at least in the absence of a public health crisis, remote arguments should never take place, and others expressing a preference for all arguments to happen over Zoom. Since they're letting me stand up here, I'm going to put my cards on the table. I don't think that Zoom compares to this room. I think the formal dignity of a setting like this courtroom in this building lends a dignity and solemnity to the proceedings that can't be replaced on video conferencing. And I am loath to voluntarily give that up. Having said that, many thoughtful lawyers disagree with me about this, and I'm sure we'll hear from them in the breakout rooms. Others have helpful suggestions for easing some of the concerns that animate the desire for remote arguments, such as adjusting oral argument times to make it easier to get to court for those who are traveling long distances. And again, I'm sure this is a discussion that we'll continue to have in the breakout rooms. I'll also note that if you haven't already, you should look at the appeals court's formal policy on what constitutes good cause for remote oral argument, which is in the new internal operating procedures that Chief Justice Green mentioned. E-filing had begun when we last gathered, but it has now been greatly expanded to the general approval of the bar, although ease of use appears to vary by user. One commenter to the survey described the e-filing system as a delight, at least as compared to Connecticut. So, fair warning if you are considering a move to Connecticut. Personally, I share the enthusiasm for being able to file from my desk. I have only a tiny bit of nostalgia for the days of walking 17 paper copies of my brief and appendices over to the SJC. I will briefly mention two recurring e-filing critiques. First, many commenters noted issues with e-service, and there were some possible fixes identified by commenters that I hope will be considered. Second, I am glad to report, if you haven't heard, that the acceptable PDF size for e-filing recently doubled, so hopefully that solves another very common complaint. That tidbit was in the appeals court's newsletter, which I only recently learned about. If you aren't getting it, you can sign up on the homepage. two final thoughts at the intersection of technology and transparency, a theme that Mark is going to pick up in a minute. Many respondents share Chief Justice Green's praise for the availability of oral arguments in both courts on YouTube. And as a side note, I will say that besides being a service to the transparency of the courts, those YouTube channels are an incredible professional development opportunity. Painful though it might be, there is nothing like watching a video of yourself giving an oral argument to learn how to do a better oral argument. And the chance to watch your excellent peers argue cases is also a great learning tool. But back to technology and transparency, a few commenters bemoaned the current unavailability of a searchable database for single justice decisions. There are some areas of the law in which the single justice is the last stop, and there are others in which the single justice is typically the only stop. And being unable to search those opinions makes it hard for practitioners to know how the justices are approaching those issues. A solution to that research gap would be welcome. I'm looking forward to the chance to talk more about these issues and so many others in our smaller groups, and first to hearing from Mark. Thank you.
Good afternoon. I am a late addition to this program, and if you're wondering why, it's because Rebecca was to share the stage with our state solicitor. Our state solicitor has other things on her mind right now. And I was asked to sub in, so it is a great pleasure to appear before you as the third choice. Let me begin by thanking Chief Justice Budd and Chief Justice Green and all the justices of the SJC and the Appeals Court, in particular Justice Kafker and Justice Hand, as well as all the members of the Steering Committee and the Planning Committee for bringing this event to fruition. I have the privilege of, in my practice, appearing in appellate courts across the country. And while there are a lot of excellent appellate jurisdictions out there, I always come home feeling very proud of our judiciary here in Massachusetts. And one of the reasons is how committed our courts are to being open and receptive to questions and suggestions from the bar. And today's event is just further proof of that. So thank you to everyone in the courts, justices and court staff for providing us with this opportunity to learn from you and to offer our input this afternoon. Rebecca mentioned transparency, and our court's commitment to transparency was an important topic at our last conference. It's worth pausing and noting how far we've come in that regard. Today, we can visit our appellate courts' websites and find them chock full of helpful information about the courts themselves, about their processes, about specific cases. There's now a wealth of guidance and forms and resources for self-represented litigants. The SJC's website now will list the cases that have recently been taken on direct and further appellate review, the cases that have been reserved and reported by the single justice, and the applications for review that are pending. We can also see the SJC's solicitation of amicus briefs, an area where I think our SJC actually leads the country in inviting non-parties expressly to weigh in on issues that are pending before the court. And on the Appeals Court's website, we now have easy access to information on just about every aspect of the appellate process, about specific cases, about the court's inner workings, including, as of just last week, the detailed new guide to operating procedures that Chief Justice Green mentioned. If you haven't had a chance to look at it, I commend it to you. If not as a sleep aid, then if you're like me, and the green line being what it is, as commuting reading, it's very, very good for that. Now, of course, transparency is not a one-time project, and we are never going to get to the point where we can say mission accomplished. More work needs to be done, and today is an opportunity indeed for us to hear from the courts and from the courts to hear from us as members of the bar about how appellate practice in Massachusetts can be made more transparent, more accessible, and more effective. And there's a lot to offer input on. Shortly after we last convened at the 2018 conference, we received the new, improved, and substantially different rules of appellate procedure. We all now, judges and practitioners alike, have had a chance to work with them. We've seen what works well, we've seen what works less well. And today we get to talk about that, and we get to begin to fine-tune the rules to make them better for everyone. And as has been mentioned, we're going to be greatly inspired by the survey that many of you filled out. For instance, I was very comforted to learn that I'm not the only one who has struggled with the rules regarding the addenda to the briefs. I argued a case in the appeals court last week and was very glad that nobody on the panel asked me to identify something in the trial court's opinion under review, because it was paginated 3 different ways. Once in the appendix, once in the addendum to the appellant's brief, and once in the appellee's addendum. And I'm sure we'll be talking about the usefulness of that today. The survey identified some other flashpoints that we can talk about. The timing for designation of contents of the appendix, the process for doing it has been mentioned. Maybe it's time to reconsider the deadline for an application for direct appellate review. Under the rules, 21 days from docketing in the appeals court, but very rarely met and very frequently extended. There are more suggestions, very helpfully, that fall under the rubric of greater transparency. There were a number of comments about the DAR and FAR process. Some respondents said it would be valuable to know when the SJC is expecting to act on a DAR or FAR application, similar to how the Supreme Court of the United States will note on the public docket when a cert petition is scheduled for conference. Others pointed out that applications are sometimes the subject of deferred action. What does that mean? Is there added information that counsel can provide in that situation to help the court make its decision? And more generally, what are the justices looking for when they're evaluating whether to grant DAR or FAR beyond the criteria that are stated in Rules 11 and 27.1. As for the appeals court, we'd love to hear more about the new en banc procedure and what alterations are being considered for it. Also about the pilot project now underway to allow self-represented litigants to file informal briefs. These are exciting new developments from the appeals court, and the bar is eager to learn more about them. I do want to offer one public service announcement to my colleagues in the bar today. This is something that emerged from our discussions on the steering committee. If you are one of the many attorneys who thinks that rebuttal at oral argument is precious and who laments its absence in Massachusetts, I feel your pain. But my understanding is the SJC tried it. Apparently they didn't care for it, and they're not going to continue with it. Now, you should feel free to use your time today however you want. But I think most appellate advocates recognize when a battle is lost, and I think that may be the case with rebuttal. May its soul rest in peace. So my best recommendation is that we're more likely to make progress on other fronts today. But once again, thank you to all who made this terrific conference possible. Thank you all for being here. Thank you for the terrific conversations that will now begin in the breakout sessions. Thank you for your attention, and let's get to work.
So we're ahead of schedule, which is the first time in history in the appellate courts. So why don't we try to get to the breakout sessions in 10 minutes, and we'll start then. Thank you.